Good morning, everyone. Today we're going to talk about legal and ethical considerations. This is coming from Chapter 6, and it's one of the most important topics in psychiatric nursing because of the legal and ethical responsibility that comes along with psych. Psychiatric nurses often work in situations where patients may not fully understand their decisions, and they can refuse treatment, or they may even be dangerous to themselves or others. And because of this, nurses must understand their ethical responsibilities, patient rights, the patient's mental health laws, documentation requirements, and legal liability. Just think of all the things that could happen with these patients. Psychiatric nursing is unique because we balance patient autonomy with safety. And let me just give you an example. A patient may refuse medicine, but if they're actively psychotic and threatening harm, the healthcare team must balance their rights with the public safety. So this chapter is going to teach you how to protect the patients themselves and then the healthcare system legally and ethically. So some objectives that we're going to go over is differentiate ethics and bioethics, explain the 6 ethical principles used in healthcare, and understand legal processes for psychiatric admission and discharges. The content is extremely important for nursing practice because many NCLEX questions involve ethical decision making, so you will see this. For example, a nurse must know when a patient can refuse treatment, or when involuntary hospitalization is justified, when confidentiality must be broken, because sometimes it has to be broken. These decisions happen every day in psychiatric care. So some ethical concepts. According to this slide, ethics is defined as the philosophical study of what is right and wrong in society, while bioethics applies those principles to healthcare situations. Ethics help guide healthcare providers when we face difficult decisions that do not really have a clear answer. In psychiatric nursing, we frequently encounter ethical dilemmas. An ethical dilemma occurs when 2 possible decisions exist, like both decisions have positive and negative consequences. An example would be maybe a suicide patient refuses treatment. So the dilemma would be, do we respect the patient's autonomy or protect the patient from harm? In this case, protecting life usually takes priority, which may lead to involuntary hospitalization. So ethics therefore provides a framework for decision making when situations are really complicated. 6 principles of bioethics. Your slide lists the 6 core ethical principles in healthcare. These principles guide nearly every healthcare decision. So the first one's autonomy. Autonomy means respecting the patient's right to make their own decision. Even if the healthcare team disagrees with the decision, patients generally have the right to choose their treatment. An example of this would be a patient with depression refuses antidepressants, and if they're competent and not in danger, then we respect their choice. However, autonomy has limits when safety becomes an issue. Beneficence means promoting good and acting in the patient's best interest. The nurse constantly asks, like, what action will most benefit this patient? For example, like encouraging therapy, medication adherence, and support systems. Non-maleficence, the principle means do no harm. In psychiatry, this is extremely important because treatments can have serious side effects. For example, an antipsychotic medication may cause the tardive dyskinesia, the metabolic syndrome, sedation. So nurses must carefully balance benefits versus potential harm. Number 4 is justice. Justice refers to fair distribution of healthcare resources. All patients deserve equal treatment regardless of their background. So psychiatric patients historically face discrimination, as we've talked about before. So justice is particularly important. And then number 5 is fidelity. Fidelity is keeping promises and maintaining trust, so patients must feel confident that the nurse will advocate for them, protect their rights, and follow through with care. So trust is essential in therapeutic relationships. Veracity means truthfulness. Healthcare providers must communicate honestly with patients about diagnosis, treatment options, and risk, even when the information is difficult. Evolving ethical issues in psychiatric care. So this slide's talking about the new ethical challenges in modern psychiatry, and these include pharmacogenetic testing, predictive psychiatry, and genetic screening. So this type of testing, the pharmacogenetic testing, is how a person's genes affect medication response. The benefit, doctors may predict which medication will work best. However, ethical considerations still exist. For example, genetic testing could reveal a risk for schizophrenia or bipolar disorder, and this information might lead to discrimination in employment or insurance. The predictive psychiatry advances in neuroscience may allow scientists to predict mental illness risk. But this raises an ethical question. Should someone be told they are likely to develop schizophrenia later in life? Some people may want to know and others may not want to know. Something to think about, right? This involves autonomy and the right to know or the right not to know. Some mental health laws. This slide introduces the legal frameworks that protect both patients and society. So mental health laws regulate psychiatric hospitalizations, patient rights, treatment decisions, and safety concerns. Psychiatric hospitalization is unique because patients may be admitted voluntarily or involuntarily. So the hospital admission process, the patients may enter psychiatric care in two main ways. So voluntary admission, the patient requests treatment. They understand their illness, they want help. A patient with depression may admit themselves for suicidal thoughts, and these patients can usually just request discharge when they're ready. An involuntary commitment is when this occurs without the patient's consent. It's used when a patient meets certain criteria. For example, they're danger to themselves, they're danger to others, they're unable to care for their basic needs, and they have severe mental illness preventing treatment decisions. So this protects patients who lack insight into their illness. So involuntary commitment is an emergency commitment. This emergency commitment allows temporary hospitalization for immediate evaluation, and this typically lasts 24 to 96 hours depending on the state law. It's used when someone appears severely confused, suicidal, violent, or unable to care for themselves. And so during this time, clinicians evaluate whether longer hospitalization is needed, and a court hearing usually follows if continued commitment is required. So which individual may need involuntary hospitalization? We're going to look at four options. A person with alcoholism who has been sober for 6 months but begins drinking again. B, an individual with schizophrenia who stops taking prescribed antipsychotic drugs. C, an individual with bipolar disorder, manic phase, who has not eaten in 4 days. Or D, someone who repeatedly phones a national TV broadcasting service with new tips. So I'll give you a minute to think about that. Okay, minute's up. Correct answer is C. I think that was pretty easy to pick out. The individual with bipolar disorder in a manic phase who has not eaten in 4 days, of course, because they may be considered gravely disabled. This means they cannot care for their basic needs like food, safety, and hygiene, so this qualifies for an involuntary treatment. So some due process in involuntary commitment. The first one, the writ of habeas corpus, is used when patients believe they've been held without just cause. and challenges unlawful detention. They can request a hearing to determine if hospitalization is justified, and even when a patient is involuntarily committed, they still have the legal rights. And then the next one on your screen is least restrictive alternative doctrine. Now, this principle states that patients should receive the least restrictive form of treatment possible. For example, an outpatient therapy should be attempted before long-term hospitalization when it's appropriate. The goal is always maximum freedom with adequate safety. Now, in the case we just looked at, however, assisted outpatient treatment could be legally mandated in most cases. So we're going to talk about discharge procedures. Discharge represents the end of the hospital-patient legal relationship. Some different types is unconditional release, where patients are stable and they're discharged without any conditions. An AMA discharge may present an ethical dilemma for clinicians. On one hand, the patient's autonomy and the right to refuse treatment support the patient's wishes for discharge, but on the other hand, the clinician beneficence would support benefiting and promoting good, which includes protecting the patient. In dialysis, we have frequently patients who will cut their treatments early, and we have them sign an AMA because they're leaving against medical advice. They're cutting their treatment, which is causing them fluid overload, and then if they refuse to come back, we make them sign an AMA. And so we have to deal with that quite frequently because it's not in their best interest to cut their treatments, of course. So again, AMA people chooses to leave before recommended discharge, and this is common in voluntary patients. They make those decisions. Conditional release. Patient must follow certain conditions such as outpatient therapy, medication adherence, and follow-up appointments. And then assisted outpatient treatment is court-ordered outpatient care. This ensures that patients remain in treatment after discharge. So this slide's talking about patient rights. We're going to discuss patient rights, including the right to treatment, the right to refuse treatment, and informed consent, and then describe patient rights and legal concerns with regard to restraint and seclusion. So psychiatric patients have the same basic rights as all medical patients, and these include right to treatment. Patients admitted to the psychiatric facilities must receive appropriate therapeutic care. They have the right to refuse treatment. Patients can refuse medications unless they're legally incompetent. A court order mandates treatment, and emergency threatens safety. These are patients' rights to refuse. Informed consent. Patients must receive information about risks, benefits, and alternatives before agreeing to treatment. Implied consent. An example of this is a patient is approached with a medication in hand, and the patient indicates a willingness to receive the medication. Implied consent has occurred. Capacity is a person's ability to make an informed decision, and competency is a legal term related to the degree of mental soundness a person has to make decisions or to carry out specific acts. So here's a case study. JS, a 27-year-old male, is court committed by his parents to your unit with a diagnosis of paranoid schizophrenia. He lashes out at staff when they attempt to give him his medication, and he states, "You are trying to poison me." JS continues to argue with staff. He is not aggressive, but refuses all treatment. Legal and client's rights are suspended when a client is hospitalized involuntarily. Is that true? Is that false? Does it depend on the state or depends on the physician assessment? And the answer is B. It's false. Involuntary admission requires that the client retain freedom from unreasonable bodily restraints, the right to informed consent, and the right to refuse medications, including psychotropic or antipsychotic medications, and other rights are preserved as well. So the family of JS ask if you can force him to take his medications. How do you respond to that? So patients who have been committed retain the right to refuse treatment. However, in an emergency, to prevent a person from causing serious and imminent harm to himself or herself or others, the individual may be medicated without a court hearing. Following a court hearing, a person can be medicated if he or she meets all of the following criteria, which is very detailed. The first one's the person has a serious mental illness. Second, the person's ability to function is deteriorating, or he or she is suffering or exhibiting threatening behavior. 3, the benefits of treatment outweigh harm. 4, the person lacks the capacity to make a reasoned decision about the treatment. And 5, less restrictive services have been found inappropriate. A lot of criteria has to be met. Continuing to talk about patient rights under the law, chemical restraints are medications or doses of medication that are not being used for the patient's condition. Chemical interventions are usually less restrictive, and they use less restrictive than physical or mechanical interventions. So nurses should consider the following before using seclusion and restraint. So things you can do before you would have to use a restraint. Verbal intervening, asking the patient for cooperation. May need to reduce the stimulation in the room. There may be a TV blaring or something like that that may be causing the patient to be agitated. Actively listening to them, listen to what they're trying to tell you, or just letting them know that you care and you're concerned about what they have to say. Provide diversion. They may be fixated on something and you have to just divert their attention somewhere else. And then, of course, offer their PRN medications as needed. So one thing, restraints and seclusion are last resort interventions, and they may only be used when a patient's violent, actively dangerous, or unable to be redirected. So orders cannot be PRN for the restraints, or they cannot be standing orders. A physician order is required and must be renewed regularly. So the goal is safety, not punishment. And then if you see on your slide, it says orders for restraints or seclusions are never written as an as-needed order or a standing order. So make sure you know that. Patient rights under law continued. So confidentiality, we're going to talk about that a little bit, protects patient privacy. We all are familiar with the HIPAA laws that restrict sharing patient information. So nurses must avoid discussing patients in public, sharing patient details on social media, and assessing records unnecessarily. Confidentiality continues even after death. So some exceptions to confidentiality would be some of these. There are situations where confidentiality's got to be broken. So examples would be threats to harm another person, child abuse reporting, elder abuse reporting. This is known as the duty to warn and protect. So if a patient tells a nurse, when I get out of here, I'm going to kill my neighbor, John Smith, the nurse cannot keep that information confidential. The healthcare team must notify authorities to warn the potential victim. So confidentiality ends when someone's life might be in danger. Okay, so our patient JS has agreed to the electroconvulsive therapy, ECT. Which member of the team is responsible for obtaining the client's informed consent? Is it the physician, the psychologist, the case manager, or the nurse? And of course, it is the physician. For consent to be effective legally, it must be informed, and generally the physician or advanced practice provider must obtain the informed consent from the patient before performing a treatment or a procedure. Patients must be informed of the following: the nature of their problem or condition, the nature and purpose of a proposed treatment, the risk and benefits of that treatment, the alternative treatment options. So next, we're going to explain the concept and legal issues regarding confidentiality in psychiatric care, and then identify some situations in which healthcare professionals have a duty to break patient confidentiality. So nurses must follow several legal frameworks, including nurse practice acts, professional standards, institutional policies, customary standards of care, and so these determine what nurses are legally allowed to do. More objectives just identify the steps nurses are advised to take if they suspect negligence or illegal activity in the provision of health care, and discuss the importance of clear and thorough documentation. So tort law is a wrongful act that causes harm to another person. There's intentional torts. Examples include assault, threatening to harm somebody, battery, physical contact without consent, false imprisonment, preventing a patient from leaving unlawfully, and defamation, damaging someone's reputation. Unintentional tort is unintended acts against another that produce injury or harm, which leads to negligence and malpractice. Negligence is failure to act as a reasonable nurse would act. Malpractice is professional negligence. For example, failing to monitor a suicide patient properly would fall under that. There are 5 elements to prove negligence, and they include duty, breach of duty, cause and fact, proximate cause, and damages. And without all 5 elements, malpractice cannot be proven. So just to hit, cause and fact is sometimes known as actual cause and may be evaluated by asking the question, like if it were not for what this nurse did or failed to do, would this injury have occurred? And the proximate cause means, or legal cause, is determined by whether the event was foreseeable. Standards for nursing care. So let's start. Nursing boards are the state governmental agencies that regulate nursing practice. Professional associations elevate the practice of its members by setting standards of excellence. Institutional policies and procedures define the criteria for care, and these criteria can be used during legal proceedings to prove that a nurse met or failed to meet them. And then custom can be used as evidence of a standard of care. So in the absence of a written policy on the use of restraint, testimony might be offered regarding the customary use of restraint in emergency situations in which the combative, violent, or confused patient posed a threat or harm to self or others. So using custom to establish a standard of care may have the same weakness as in using hospital policies and procedures. After all, customs may not comply with the laws, recommendations of the accrediting body, or other recognized standard of care. And that was a mouthful. Sorry. So nursing boards are state governmental agencies that regulate nursing practice and whose primary goal is to protect the health of the public by overseeing the safe practice of nursing. They have the authority to license nurses who meet a minimum competency score on board examinations, and also the power to revoke license. Each state has its own Nurse Practice Act and identifies the qualifications for registered nurses, identifies the titles that registered nurses will use, defines what nurses are legally allowed to do, and we call that the scope of practice, and describes the action that are followed if nurses do not follow the nursing law. So which of the following identifies the titles that registered nurses will use and what they are legally allowed to do? Easy peasy, State Board of Nursing, of course. All I'm going to say on this slide is you have the duty to intervene and the duty to report any incompetence, impairment, or any criminal activity that you are aware of. Documentation is one of the most important legal protections for nurses. Make sure that you document. The medical record must be accurate, complete, and timely. And there's a common legal rule that states if it's not documented, it did not happen, and that is so true. You must document. It's used for communication between the healthcare providers, quality improvement, and legal advice. The patient has a right to review that record, and the record belongs to the institution. And this slide just reiterates the same thing I just said. It's used for quality improvement, as evidence in a malpractice suit, used for risk management purposes, determine insurance reimbursement. So medical records are important. So talking about medical records as evidence, they're used to determine the extent of patient's damages and suffering or in a suit, nature and extent of injuries and abuse cases, nature and extent of physical or mental disability in disability cases, nature and extent of injury and rehabilitative potential in workers' compensations cases. So very, very important documentations. So guidelines for electronic documentation. I'm just going to read the slide. It manages data and communication, reduces errors, and facilitates decision making. Federal privacy laws on access. Courts assume if it's not documented, it did not happen, and specific rules and timeframes for correcting errors. Forensic nursing. A lot of times we'll hear students interested in forensic nursing. So forensic nursing applies nursing knowledge to legal investigations in court cases. Forensic nurses may evaluate competency, ability to stand trial, and mental responsibility for crimes. They may also testify in court and be expert witnesses. So from the screen, application of nursing principles in a court of law to assist a decision. Nurse often educates the court on the science of nursing and may provide opinions using appropriate nursing standards. Some issues at stake may include patient competency, individual's fitness to stand trial, involuntary commitment or responsibility for a crime. Support of victims or perpetrators of crime and violence, collection of evidence, provision of health care in prison settings are some things that may be additional tasks. So to identify healthcare workers' legal protection from violence in the healthcare setting. Violence in psychiatric setting. Nurses must participate in setting policies that create and maintain a safe environment. Always document the patient's potential for violence. Communicate observations to your colleagues. And use new laws enhance criminal charges. Excuse me, and penalties for striking nurses and other healthcare workers in the course of duty. So healthcare laws now provide stronger legal protection for nurses that are assaulted at work, because it does happen. And usually a prosecutor will not bring charges against disoriented, delirious, psychotic, or otherwise mentally impaired patients. However, violent patients, friends of patients, and family members who are aware of their actions can be charged with serious crimes. So just keep that in mind. Thank you all. I know this was lengthy. Hope you have a wonderful day.